All right. Good afternoon, everyone. Dear panelists, thank you for joining today, and all our participants who have already joined and are joining. My name is Jagmeet Makkar, and I'm the chairman of the Hong Kong branch of the Institute of Chartered Shipbrokers. On behalf of the executive committee of ICS Hong Kong and the co-organizers of this event, who are the Singapore and Middle East branches of the ICS, I welcome you to today's webinar. It is important and highly recommended to use the standard forms and preferably use their latest versions for the shipping contracts, namely the charter party, ship sale and purchase, ship management, etc. The most recent versions incorporate uh, the contemporary practices as well as the changes reflecting the development in case law since the last version. BIMCO carries out this very important exercise through its documentary committee and industry consultation process. However, many practitioners tend to keep working with older versions of the forms, resulting in the executed contract main body looking like a battlefield with rider clauses running into 70 to 80 pages. ICS Hong Kong branch is delighted to bring together an eminent panel and moderator who will look at the Shipman 2009 and the BIMCO, which is the BIMCO ship management contract, and it is the most commonly used form. From their practical experience, both the ship owner and the ship manager's perspectives, our panel and moderator will explore industry practices and also suggest changes to the standard form in the next revision. Amongst the other issues they may consider would be jurisdictional ones, certain provisions regarding obligations, indemnities, liability to the owners, limitation of liability, importance of naming the manager as joint assured, and how English law and US law look at the issue of limiting liability by a party for its own fault. A good understanding of the ship management contract is the most important, if not prerequisite, for the practitioners. Before I hand over to the moderator, it is my utmost pleasure to introduce Mr. Sharad Gupta, a shipping professional with more than 25 years of experience, both on board and ashore. Sharad is a fellow and executive committee member of the ICS Hong Kong, with additional responsibility of being the education and examination officer of the branch. He also completed an executive leadership program with Stanford University, California. Sharad contributes to the events in the Hong Kong Maritime Week, is a regular teacher at ICS preparatory courses, as well as is a guest faculty at the MPPF classes for budding mariners in Hong Kong. Sharad is a regular contributor to maritime publications and a speaker at industry seminars and also webinars. Sharad, all yours.
Thank you, Jagmeet-san, for your kind opening remarks and for leading us into this event today. Greetings of the day to all those who managed to join us. I see we are approaching the 100 mark now out of the 240 odd that have registered. Hopefully this number will keep climbing as we go along. Today is not supposed to be an educational or guidance session for the industry practitioners who are experts. It's more of a session for all of us, the general practitioners in the industry. And we hope that all of us can actually take back something, some food for thought after the next hour or so. In addition to the questions which we pose to the panelists, please feel free to use the Q&A box. Please don't use the chat box. Please use Q&A box to post your questions, and we will try and address them to the panelists towards the end of the session. We have an all-star cast of panelists today, including legal, business, and technical backgrounds. Leading the star cast is Ms. Katherine Smith. She's a general counsel and company secretary at Wah Kwong Maritime, a solicitor qualified in England, Wales, Scotland, and Hong Kong. She's also a fellow of the Chartered Institute of Arbitrators. She has substantial experience working on complex shipping matters, both contentious and non-contentious, including ship leasing, finance matters, S&P, as well as disputes arising out of charter party and bill of lading contracts. She's experienced in multiple jurisdictions, including the English and Hong Kong High Courts, and various arbitration fora, such as the LMAA and HKIAC. Welcome, Katherine. Thank you for joining us. With Katherine on the panel, we also have Martin Henry, who is the CEO at Tamar Ship Management Hong Kong Limited, a Class 1 marine engineer and a fellow of the ICSHK. Martin has 14 years of seagoing experience all the way up to a chief engineer officer. With over 21 years of experience in ship management in various roles, he has been responsible for all aspects of ship management, including crewing, safety, insurance, dry docking, new buildings, accident investigations, you name it. Prior joining Tamar, Martin worked most recently for 7 years as technical director at CMA Ships Limited, and another 6 years as technical director at Carisbrook Shipping. Welcome and thank you, Martin. Our final panelist, Captain Vikas Graval, is a director of business development at Pvt Management Limited. Seasoned maritime professional, he drives fleet's core strategies for growth and leads conversations around marine asset management, lifetime cost cycle forecast, and other industry trends with world-class ship owners, shipping funds, and financial institutions around the globe. Captain Graval started his seagoing career in 1994 and sailed on a wide range of vessels managed by Univan, MOL, and Fleet. In 2004, he commenced his short career at CSAF before joining Fleet in 2009 as Marine Manager, Business Division. Having led the division since 2014, he assumed the role of a Director of Business Development in 2020, which is where he is now. Welcome, Vikas, and thanks for joining us. All right, so we get to the interesting bits now. Thank you for all of you once again for joining us. A very general question as an icebreaker, a very obvious one as well, with so many versions of the document floating around. To all panelists, we'll start with Martin. Which version of the SHIPMAN would you prefer in your present position or your point of view, and why?
Yep. Hi, Sharad. My view is pretty simplistic. I prefer the SHIPMAN 2009, mainly because I'm mostly familiar with it compared to the 98. Because before the 2009 came out, I was probably less involved in dealing with these documents. Now, more recently, in the last few years, I've been dealing with them quite a lot, and it's almost always been 2009. You know, when I compare them, I feel that that it's better laid out, and as was mentioned earlier by Jagmeet, you do end up with a lot of riders after if you use the SHIPMAN 98. So that's my view.
Fair enough. That's a pretty practical approach. I'll then invite Vikas for a little bit of a business aspect on this.
Well, commercially, I would always favor 2009 because many of the commercial aspects, be it termination fee or be it the superintendent's fee, these concepts are not right up front and center in part 1 of the agreement. So we have a concept of termination fee, but it comes in clause 8.4 in the SHIPMAN 98. And there is no mention of superintendent's fees for superintendents who visit on board, and extra resources are used on that account. But all these commercial matters are brought in to the part 1, first page of the agreement where a person signs. And so the negotiation becomes so easy. So it becomes, that the BIMCO states that these concepts are industry standards. And so a lot less time is spent in explaining why they are there. The rationale is upfront and clear. And then there are explanatory notes that BIMCO has provided for SHIPMAN 2009 and 1998. For anybody to bridge the gap becomes extremely easy. And so I would prefer 2009. Also, 2009 brings in the concept of bareboat charter, which is not there in 1998. And so, at least 10 to 15% of the ships we manage, out of the 600 odd that we have today, are signed with bareboat charters. And so this concept doesn't exist in 1998. So the obvious choice is to use 2009. So those are the reasons that I would go for 2009.
Right, pretty compelling reasons as well, some of them, yeah. Katherine, your take?
I agree with my eminent panelists on all of the practical, operational and commercial for exactly those practical, operational and commercial reasons. In addition, purely from a legal position, I would also prefer, and I think Wakwang would also prefer SHIPMAN 2009, because the disputes resolution clause has been updated from 98, as Jagmeet alluded to at the very beginning. Those clauses have been updated to take into account developments in law generally, and also because there's a distinction with the where there may be a distinction with the ISM DOC holder, where that company may not be the contractual manager. In many cases they will be the same, but in some they may not. And the very front page of Part 1 of SHIPMAN 2009 provides for that. I also agree absolutely with Vikas's point regarding bareboat charter and that concept having been included. We also deal with managing of bareboat charter vessels too, so that addition is also very welcome.
Fair enough. Yeah, thank you. And Katherine did bring up the name of Wakwang, so I would just like to add a little disclaimer on behalf of all the panelists that whatever we talk about today, whatever views, these are individual views of all the panelists. They are not necessarily the official position of any of the organization involved, including the employers of the panelists. And so please, anybody who takes away anything from this is just for informational purposes. And please do check at your end before you incorporate any of the viewpoints into any of your dealings. Thank you. All right, so we get into a bit of a specifics of the SHIPMAN. And again, asking Martin Henry first, in all your dealings with your clients, what would be the most common areas that you've come across where you've had several discussions back and forth with your clients, especially with regards to riders added? And moreover, in retrospect, can you recall any specific instances where you would have rather added a rider clause than just gone with a standard clause in the SHIPMAN 98 or 2009, for example?
This is where you've got me, because I haven't really got a good answer for you on this one, I'm afraid. I think, if there's been any disputes or back and forths, for me, it's usually been at the time of preparing the agreement and things that maybe owners want in or out, and we try to fight to keep in, usually. But there's not been a lot of that, and I've never really had any major problems after the event, so might be better that Vikas answers that one instead.
Lucky you, Vikas.
All right. So more often than not, I think the BIMCO 2009 is very well laid out in terms of commercial terms and also in terms of other clauses for liability and all the legal clauses that Katherine would expand on. In particular, if there is something that usually becomes a negotiation point or why it should be there, is something related to deposits and working capital funds. So primarily, if you would see clause 13 of the funding clause, it alludes to the funds being paid at the start of the month for the ensuing month. But the practical implication is that although the budget is an annual budget and 1/12 the budget is paid every month, managers commit a lot. So we don't buy 1 month of lube oil at a time. We buy 6 months of lube oil at a time. We don't buy, we don't pay insurance if we are doing insurance on those behalf. We pay P&I clubs every 3 months. We don't pay them every month. So because of this, on average, the payment process to vendors itself takes 40 to 45 days. And we find that although we get funds just for 1 month, we end up committing the owner as their agents to vendors worldwide for 3, 4, 5 months worth of technical items in particular. And because of this, we usually ask for what you can call it a deposit or a working fund for a certain multiple number of months of the OPEX. And not only for that purpose, but also for the purpose of as us fleet management or a manager is usually entered as a co-assured in the P&I cover and also the H&M cover notes. And because you are entered as a co-assured, what happens is in case, God forbid, the owner goes bankrupt or doesn't pay the P&I premiums for any reason whatsoever, he then, the co-assured becomes liable for those unpaid premiums. And so for all these reasons, number one, the prospect of unpaid premium that we might have to shell out. And number two, because the whole concept of we committing to 3, 4, 5 months of technical costs at a time and not 1 month, there is a need for a working capital or a deposit to be paid upfront, which we can tap into to make payments. And this is something that usually we ask, and we see that it's started to become commonplace amongst managers. So many of our peers ask for it today. And this is something that owners appreciate as well, and is becoming commonplace. The other thing that usually we negotiate upon and is not in the standard BIMCO contracts is sanctions. So there is a sanctions clause now, but not integral part of it, which has come about in the last few years. But for many years, we were, I think for 7, 8 years, we were adding sanctions clauses and owners were tweaking it out. And that becomes a discussion point. So these two points, I think deposit working capital and sanctions are still non-standard, which we need to talk about every time when we are negotiating a contract.
I'll bring in Katherine to comment on these riders because not so much with 2009, but obviously with the previous versions, the riders used to be more pages, more lines than the actual shipment itself. So how often do you see any of these riders being thrown out in a court of law or even during arbitration? Any interesting ones?
So in preparation for this panel, I scoured through the Lloyd's Law reports and the Lloyd's Maritime Law newsletter for reported arbitration cases and also reported maritime court cases on shipman contracts. And alas, I'm sorry to say, could not find many other than the famous cases that we all know that actually don't go to this specific point. And I think the reason for that is that if there are any such disputes between owners and managers, they're dealt with in arbitration. And it's a decision between the parties to that arbitration as to whether or not they agree to have their arbitration award redacted, but published in the Lloyd's arbitration newsletters on arbitration. So I'm sorry to say, having gone through my iLaw account for some time over the last few days, I couldn't pick up on any cases or examples where a rider has been held to be invalid, illegal, struck out by an arbitration tribunal. That's separate to the point which I guess we'll come on to later regarding how the US maritime tribunals and courts would treat an exclusion or a limitation of liability clause. But certainly from the point of view of LMAA and or English courts, which is what the majority of, for right or wrong, what the majority of our contracts contain, I wasn't able to come across some reported cases that say that speak to removal of such rider clauses, I'm sorry to say. Or maybe that's not a bad thing, and maybe that's a good thing that there are fewer disputes than we think there might be. or they're
True.
resolved commercially sensibly as between the parties.
Yeah, I mean, that's 3 cheers for the in-house counsels or the people who are drafting the clauses. Yeah, we always talk about don't draft your clauses. So riders, yeah, that's not too bad actually.
Exactly that.
Okay, so a little bit of a googly, if I may use the word, for Martin and for Katherine as well, since both of your companies are sort of walking a little bit of a tightrope between being in-house managers and aggressive third-party managers as well. Do you see any conflicts or complaints coming from, let's say, the third-party owners' clients, especially when it comes to benchmarking or quality management of own versus third-party tonnage? Martin?
No, not as yet. I can see where you're coming from, though. There may be ideas that maybe people they don't want looking at their information, but we operate. Tamar Ship Management is a completely separate company from any of the ship owners that we work with, and we maintain that even though we're on the same floor as one of them in a building. We continue with them as we would with anybody else, any other owner that comes to us. So there may have been in the past, but they've never come along and said that it's been an issue.
Okay, that's nice. Let's keep it that way for you then.
Yes, absolutely, yeah.
Your experience, Katherine, any interesting ones?
So maybe again, too much with my lawyery hat on, I wouldn't necessarily use the phrase walking a tightrope. Certainly, and again, not to sound like I'm doing an advertisement for Wakong, but the way we operate, which sounds slightly different to that of Tamar, is that the ship operations management team that manage and operate Wakong vessels are the same people who manage third-party vessels. So it's the same team, it's the same procedures, it's the same processes being applied across the board. And I would also add that the standard term within the ship management agreement, which goes to the spirit and spirit of the entire agreement, is that managers use their best endeavors to provide management services according to sound ship management practices. And that happens across the board in respect of our own vessels as well as our third-party vessels, which I know comes across as a party line, but that's very much the reality of the situation.
Right. Well, that's good to know. I mean, obviously, the lesser disputes there are more smoother functioning we can all have, no doubt about that. So looking at a very specific aspect of SHIPMAN, the role of managers as agents only. Now, there have been several cases where managers ended up being held fully liable because of the simple fact that their role as agents only had not been fully clarified from the onset or fully spelt. So how would you deal within your organization? And I mean at all levels, including masters and ship office staff. How would you deal with a situation like this and ensure protection against this kind of a scenario? If we may start with Martin.
Well, I'll start with the obvious ones. Make sure you've got that acting as agents on behalf of the owners on everything you can, on the bottom of an email, on every purchase order that goes out, every contract that's there, on the master's emails, any company stamps that exist for captains and so on, and you just plaster it everywhere you can, really, to make sure it's very clear. It's very rare these days that someone comes back with a question about that. They usually must be new in the business or something like that. It's very rare. Right.
I think Vikas has some a different view on that. Sorry, Vikas?
No, I would agree totally. You don't look for conspiracy over here, Sharon. I would agree with Martin, absolutely. I have not heard of this becoming a problem. Although owners expect us to be more than agents, the risk to reward ratio that third party as a segment has become is clearly we don't earn more than what an agent can. So, so in that sense, yes, to protect ourselves and to make it clear in talking to vendors right from the onset, to all the invoices when we place orders, in the contracts of the crew themselves, and in all our emails, of course, we mention that we are as agents only, and that's the only thing that we do, really, nothing much more than that. And that has, in my 12 years at Fleet, 13 years at Fleet, I have not seen people coming back and asking otherwise. They do push in the shipman when negotiating. They like us to take more responsibility just as agents, but they understand that we are agents only. And usually when you explain the risk reward ratio, they go back and all our agreements are as agents only.
Right. Katherine, have you had any such instances? I mean, examples like bills of lading being presented in an incorrect manner or something like that, where this role as agents only was under question?
No, thankfully, and I'm touching wood in my head as I say that. But I think one thing that's really interesting, I'd be interested to hear what the other panelists have to say on this, is in terms of the relationship as agent, as manager, and as agent only in assisting owners in the defence or management of claims. How far are we responsible for working directly with the claimant in trying to resolve and settle claims on behalf of an owner, particularly in our situation? I'm sure this happens to a number of people out there as well, where the registered owner is a financial institution. So, and they don't have claims departments, and they're not used to dealing with cargo disputes and P&I clubs and LOIs. The extent to which the manager is really responsible for driving and managing the claims as much as they are the vessels. So we haven't had situations where we've been treated as principal. However, there's sort of a question, or sort of kind of a grey area in a way, where we conduct ourselves almost in the shoes of the principal in respect of dealing with and settling claims. And that for me is where our overall role is. It is an interesting one to discuss or consider.
Okay. Vikas, you'd mentioned the aspect of P&I calls and deposits towards working capital as being part of your initial discussions with clients. So would you consider that these deposits which you take from your clients at the onset, are they sufficient to cover most of the liabilities, including something unusual such as a P&I call finding its way on your desk in case the owner goes bankrupt?
So what you can do about that is that, yes, since we have started to put in the deposit, it is usually sufficient, but you can also be prudent and not let these pile on. And what do you mean by not let it pile on is that every 3 months, when the P&I premium is paid, and if it is paid by the owner, you could be proactive and ask for an evidence. And usually if you ask the deposit, then there is no need to. And of course, you get the annual cover note renewed coming to you every year. So you know that it has been paid, otherwise you would not get that cover note. But, and then for the remaining of the year, you have this deposit, right? But suppose somebody refuses to pay the deposit and you still want to continue with the relationship because of the volume or whatever commercial reasons. What you could do as a minimum is put in a clause to request that every 3 months when the premiums are paid, if you're not arranging the premium on behalf of them, they show you the evidence that it is paid, so that the outstanding liability that comes to you is limited to that 3 months. And of course, you do this depending upon the relationship with the owner and how, what you think of their credentials and how well you know them. But this is something that you could do. But if you take the deposit, of course, the deposit that we agree and owners pay is sufficient for their 1 year of premium. Yeah.
Katherine, do you also follow a similar line as a company, as a lawyer, legal department?
Yep, we do. In terms of maintenance of additional funds to cover such costs, we certainly do try to negotiate that with our owners. The other point, just listening to Vikas about budgets and Annex C in particular is the wording of Annex C manages initial budget with the effect from the commencement of the date of the agreement. Our experience is also that there's additional sort of upfront costs of bringing the vessel into management in the first place. So, for example, implementing ship management systems, various other things that are sort of almost costs the manager incurs in preparation before the takeover of the vessel into management. And the form itself, if we're going to talk about it, sort of improving the form, whether there could be an improvement there would be sort of upfront preparation costs before you get to OPEX budget costs. I think would be really helpful for both parties to have clarity about where the different costs are and when owners might be expected to pay a lump sum upfront for preparation costs, actually, so that there's no surprises. I don't know if that's what my fellow panelists do in practice as well, or whether they have any, whether that's something that gives rise to further discussions or any friction with new owners.
So Katherine, what we do essentially is that we, as one of the rider clauses, make it clear, and this is such a good point, because what happens is the agreement commences on the date the vessel is taken over, right? So the agreement
Yeah.
has not even begun and you have incurred so many costs.
Exactly.
And of course, there's an email where they confirm that the pre-delivery is okay, but it's still not a signed contract in which it is there. So in the signed contract, we put a rider clause saying that it is understood and agreed between owners and managers that some pre-delivery funds and everything, you know, the costs have been incurred, will be incurred towards preparing the takeover. And in case, and these are agreed and put in the Annex C as OPEX and pre-delivery, so we paste both. Yep. And we say, in case for any reason, the vessel takeover is suspended or doesn't take place for any commercial reason or whatever, then all actual costs that the managers will incur will be paid for by the owners.
Yeah.
So we clarify this because the agreement might not even commence, you incur it, and then you never take over the vessel, and who pays for it?
Yep.
Yeah.
Maybe that's a tip for the BIMCO drafting team for the next iteration of this document to include in that Annex C.
Absolutely.
I think that's a very interesting point, Vikas, which you raised, is the situation where a contract has not actually been signed. And this is something which is extended not just to Shipman, any other contract in the world that we talk about. So I think Katherine can just put in a line on when does a contract actually become enforceable, even if it's not being signed?
So in the Shipman contract, it's signed, but at the very start of the box, what does it say about commencement? So the date of the contract itself may be dated and signed by parties, but the commencement of the agreement might be a different date later in time. So if you have got a binding agreement as between parties at the time it's signed and dated, but the commencements of performance of the agreement is a later date. So I would say that in the circumstances in which costs have been incurred in anticipation of performance of the agreement at the commencement date, such costs should be recoverable by the party that's incurred those costs. Now, whether that's under contract or whether it's something under a damages claim in tort or in equity, an equitable recovery of costs incurred in anticipation of performing a contract, I'd have to think about a bit further. And also where you would be looking to recover those costs from your owner that's a single party company in a far off jurisdiction, right, may be really difficult. Or if your contract's subject to somewhere other than Hong Kong, Singapore, English familiar jurisdictions, and you're trying to enforce that against your owner in a difficult jurisdiction, that gives rise to litigation risk and cost risk. So all the more reason to put that in Annex C in the first place. That that even if costs have been incurred, they're recoverable, even though the commencement date of the agreement has not necessarily yet been met. But we could talk a lot about parties' intentions and their conduct that evidences that a contract's been entered into, and all of those things. But maybe that's a more of an academic legal contract law lecture for Jagmeet and others another day.
Yeah, I'm sure he has a lot to say on that. He's
Indeed.
really an interesting one on that one, for sure. All right. Another area which tends to be more interesting, more so these days, where a lot of ship owners are taking on professional mariners with suitable background in their offices, is the area of managers' discretion and how involved the owners are becoming in day-to-day running of ships. So, Vikas, your thoughts on that?
Well, my thoughts are that a manager has the obligation to maintain his DOC, and obviously, he would not put the DOC on risk. And that basic premise means that it should be left to the manager to decide what resource he allocates to which ship and when. And that's why I think in the 98 as well as the 2009 formats, leaving it to the manager, and we will, it's left to the manager's discretion, and that's the way it should be. Of course, I speak from the manager's perspective. I have not seen a single case where it has gone into litigation where they have claimed that the manager, in particular, talking about at Fleet, that we have not put our resources fairly or justly between our owners. But yes, because of that reason, we are responsible for the DOC, and we will not risk our DOC, and so it implies that we can be trusted for that, to save our own interests, and so the discretion should lie with us.
Right. Martin, you've had any experiences where there's been a bit of a pushback one way or the other in the area of managed discretion because of owners getting more than active,
Well, there can be, there's, as you know, every owner is different, and then there's some that are more vocal and more involved than others that don't say a lot. There's all different kinds.
Yeah.
And sometimes the more vocal ones that may also have a sort of owner's representative that's quite quite strong. It can get a little like that, but in the end, normally when it comes to the, let's say, crunch, the managers always have to and they will step up, because as Vikas said, the DOC is like the Bible. It's something that we want to keep forever.
Katherine, any boxing matches you've come across on this matter?
I haven't seen from my colleagues in our Shipman side and operations side boxing matches, but sort of in an earlier stage in drafting and negotiating Shipman Part 2 of the Shipman form, sometimes owners will like to sort of amend or seek to amend Clause 8 managers' obligations. So I've seen things where the absolute discretion has been struck out and tried to sort of water it down in a way to a reasonable discretion. I kind of question the purpose of that and whether that really assists both owners and managers in understanding where their responsibilities and obligations lie. So if the wording is that managers in their absolute discretion considered to be fair and reasonable, but if that's amended to say something like their reasonable discretion, as they consider to be fair and reasonable, you end up with a double reasonable. You're like, well, what's reasonably reasonable? And also I would say, I don't think sort of such an amendment necessarily, again, with manager's hat on, leaving absolute discretion, that's already tempered by the best endeavours, and to carry out that discretion with sound ship management practice and to protect and promote the interests of the owners. So you're looking at your managers exercising their absolute discretion in that context anyway, which must be carried out reasonably as a prudent manager would perform their management services in any event. So I'm not sure whether having sort of boxing matches earlier on in trying to amend or change that clause in particular really assists both parties in the context of the rest of the contract.
Right. Another, I mean, just an iteration of the same one is that the question of non-budget expenses, it always tends to be a thorny issue. Martin, what do you think can be done as a process? I mean, besides an open dialogue at all stages, is there anything we can do as an industry to improve this aspect?
I mean, there can be. That with many of the owners that we work with, we have a set of what we would call, I guess, standard reporting requirements. And that's, you know, an in-house document that we put together and propose that to the owners. And occasionally, you know, they will make their own adjustments. That'll have everything from what the normal OPEX reporting and maybe what the when and who to report at certain levels of emergency or things like this. But it'll also have levels of unbudgeted expenses, which areas which they cover, and when you need to ask for permission and when you don't, type thing. So it's sort of, you know, it's documented so everybody knows when they have to put their hand up, without thinking, do I need to put my hand up because I've got to order a new toilet seat and I didn't budget for it? You know, you obviously don't want to do that, and you probably wouldn't do that, but you know, it's maybe not a great example. But yeah, that's how we handle it. I mean, I suppose you could standardize that type of thing and add it to a SHIPMAN as an annex or something like that, but I'm not sure what other people do.
Vikas, your take?
Yes, indeed, this is not a thorny topic, but yes, it is an important topic for discussion because expectation management is extremely important for a long and trustful relationship. In that, we at the onset propose a minimum non-budget cost over which approvals will be taken, which can be negotiated. So instead of listing a lot of things that are or will be taken approval for, we say that anything over this value of non-budget items, we will take prior approval for the owners. Emergency is accepted because we don't want it to limit the speed with which we might need to act in emergencies.
Right. Yeah. Of course, the hot topic these days is COVID, and we probably haven't yet seen many disputes arising out of it. But Katherine, in the foreseeable future, what kind of disputes and claims do you see coming into the arbitration or courts of law with regards to SHIPMAN itself?
Hopefully none. Of course, we would say, I suppose, and it's sort of sad to say, in relation to crew management, whether or not managers have used best endeavours to arrange for crew change in difficult times, maybe there'll be those types of cases. I know certainly looking at it from the other end of the spectrum, oil majors are treating how long crew have been on board and whether crew have managed to get home and have leave as a safety matter, rightly, and so if you look at it from a ship manager's perspective or a crew manager's perspective, the steps that managers are taking to use their best endeavours to arrange for crew to be on board and that crew haven't exceeded their contracts or statutory time on board may be something that comes to light. Again, it's a really tricky one in the very challenging circumstances in which managers and crew managers are operating and trying their best for crew, but that may be something that could arise post-COVID. Let's hope post-COVID comes sooner than later.
Yeah, I mean, because we obviously already beginning to see a lot of discussion between owners and charterers on the matter of these extra costs. So some of them will probably, hopefully not, start to hit the desk of ship managers as well. Staying on the legal aspect, one specifically legal question for you, Catherine, is with regards to how different jurisdictions treat SHIPMAN 2009. You know, the US law doesn't look at several clauses very kindly, such as the 10 times management fee limit, etc. Where does the Chinese law stand in this regard with regards to SHIPMAN agreements?
I do not know. I'm sorry. I should have studied this before we came. I do not know how PRC courts or tribunals view exclusion or limitation of liability clauses. We certainly know what the position is in the US. I'm also not a US lawyer, but we are aware that they really don't like those clauses unless they've, particularly where they're in standard print form, and prefer to see or require to see evidence of negotiation between the parties on such exclusion and limitation clauses for them to be seen as not unfair contract terms. But I'm not sure if Jagmeet has a better understanding of what happens under Chinese law.
Okay, so I would assume that in your present position, most of your clients do accept the English law, even though they may be Chinese PRC-based owners. Yeah?
Yep.
I would actually ask Jagmeet-san for a quick bit on this one.
I think there is no clear-cut and straightforward answer, except that what I can say, Chinese courts are quite serious about the relationship between the parties. They tend to consider managers as the company, right? Unless the contract itself says very clearly that it's as agents only, it should be part of the contract, not just writing as agents only on every email or fax or message that goes out. They have considered, I just posted something on the chat a little while ago. It's very important to establish that. If they consider manager as the carrier, you can very well imagine what liabilities the managers can have. Although the ship management contract does talk about the owner indemnifying manager for every loss, but it can become little tricky. Thanks.
All right. Thank you. Thank you.
Just to add to that, I mean, that's also the position under English law, so that even if you say you're the agent and everybody kind of knows and anticipates that, assumes that you're the agent, unless there is an agency agreement in place, you may be treated as the principal. So that's the same principle under English law.
So picking up on the question of US law, if you as third-party managers end up in a situation where one of your owners want the US law to be the consideration for the shipman contract, would you take the ships into your management? Martin?
Well, I never say never, but I'd have to definitely get some legal advice. And as I've never dealt with US courts, I doubt they've got the experience that other courts may have for, specialist sort of marine cases or cases that involve disputes with ship managers. I doubt you'll be able to find a lot of evidence of that. So I would prefer not to, but I would never say never.
We're playing it safe this evening, aren't we? Vikas, your thoughts on that?
Well, I would definitely say no. Something that I don't know, and since it's a personal view, not an organization view,
Yeah.
so I would definitely say no to that. And it's fair, it's reasonable that both parties agree to something that is standard, where there is case laws to understand what you're getting into. It's just not fair for me to enter into a contract I don't understand.
Fair enough. Catherine, you mentioned you're not a US lawyer, but I'm sure you have thoughts on that one as well.
I've got some friends that are on speed dial, but if our chairman or our Captain Joe, who's the MD of our ship asset management department, were to ask me whether or not we should enter into a shipman contract subject to US law, I would certainly, as Martin said, take take some pretty serious US law advice on potential liability under such a contract. And I think ITIC and P&I clubs would be pretty interested in seeing that too before we were going to enter into any such agreement, and what additional premiums would be payable under ship management liability insurance too.
Fair enough, yeah. The lawyers answered.
The lawyers answer.
Right. Okay, before we take the questions which are being posted on our chat box, just one final comment from all the three panelists. If you had the choice to put one or two clauses into the next Shipman 2022, what would be your preferred suggestions? Let's start with Martin.
Well, yeah, I mean, I would definitely like to have Vikas's deposit from all of the ship owners. That would be very nice. I'd love that. Yeah, bring that one on. One thing I would probably like is, you know, every year or two, there's some quite major new regulations coming in. And of course, it's our responsibility to make sure the ships stay inside the regulations and are fully certified and everything. But as more and more things come in, you know, they take a lot more resources, they take a lot more time. And sometimes you are able to put your hand out and ask for some money for that, but sometimes you're not. Sometimes you're just, it's an expectation that it falls within your remit. And I think that there may be a clause that somehow raises that a bit more clearly, that sort of says, you know, if something new comes along, we'd like to talk about it, and, you know, somehow raise that a little bit.
Okay. Because one of yours is already taken up, so.
No, it's all right. I have many more. But yes, first on the list would be the part A of the agreement. I would prefer that the deposit clause is made front and center, so that the parties can discuss it openly instead of keeping it as a rider clause, and when they finish the whole agreement, they find what is this about, and they come back to us. So that can be made front and center. We have, as Katherine suggested, about the pre-delivery costs to also be mentioned there. So we presently put it as a rider clause. Why not make that up front and center as well? So commercially, I find that these two clauses should be there. Sanctions and MLC clauses, BIMCO has drafted them, but they're still not part of the agreement. So you need to copy paste and insert them in. So please make that standard and into it already. So this would be enough for me, and I think it would be quite, it would cover everything that I need.
Okay, fair enough. Let's keep the wish list coming. Katherine?
Yeah, I think Martin and Vikas have really covered my wish list. Is certainly adding the BIMCO sanctions clause or versions of it, and also setting out that Annex C with a bit more structure. I think I can see why the drafters maybe didn't do it, because they want to leave the parties to negotiate these points commercially themselves. But actually, I think having a bit of structure helps everybody in the negotiation, and making sure there's no surprises.
Right. Okay. So, all right. Thank you so much for those inputs on the next Shipman. I'm actually going to open up the Q&A box and see if we have something interesting there. There's one question from Mr. Edwin Wong. It says, in a casualty-related incident, especially major ones, does the fixed ship management fee cover all the extra manpower and management time? Or is that a separate cost to be reimbursed? So management time is an interesting one. Vikas, would you like to comment on that?
So management time is, of course, but not the cost related to the expense. That would be non-budget.
Right. Anything to add to that, Katherine?
No.
No.
Yeah, those would be additional costs of superintendents or whoever it may be attending on board, and all of the things that we required in a major casualty.
Right. Okay, we have one more from Mr. Anil Arora. There are many cases where negligence of crew or manager's office staff is clearly established, which has led to a loss to owners. Saying sorry and apologizing may not be enough. How does an owner claim compensation for such a loss? And does a manager have insurance to cover this scenario? Catherine?
Manager does have insurance for liabilities arising from conducting a ship management agreement. We've already spoken about limitation of liability to 10 times the management fee. Whether or not negligence, gross negligence, or willful defaults is easily proven is another thing. And that has resulted in a loss to owners. I'm not entirely sure that that is something that is obvious or happens all the time. Yeah, I mean, that's something that claims handlers and shipping litigation lawyers make a living from. But certainly, given the nature of the relationship between the owner and the ship manager, where the manager is entrusted with the asset of the owner, it's a collaborative relationship, I would say. And so whether there's constant disputes and litigation during the course of the performance of the shipman agreement, whether that's something that both parties really want is another point.
Okay, that's something which probably will require a little more thought than just this little platform here. We have one question with regards to COVID-19 again from Mr. Bharat. Let me see if I can read. What rider clauses pertaining to COVID-19 can be incorporated in SHIPMAN from managers' perspective who are actually involved in hiring of ship staff on board, emphasizing the current scenario where Indian nationals are being replaced by other nationalities? Any thoughts from the panelists? I'm not quite sure what's the intent here. Could it be that there's been a change in costs agreed as part of SHIPMAN because the nationalities are being replaced simply because of restrictions in COVID? Could that be the case?
Well, sometimes owners, because of commercial reasons or because the vessels are going to dry dock and then they won't allow a crew change in a certain period if they're going to Zaoshan and all those things came about. Or there's a change of ownership and there are existing Indian nationals on board and owners are wary of them and things like that. It's more of fear, and I think it's more of education that is required. So far as you can put across, one thing is about avoiding it, and I'll come to the clause, but you can easily avoid, and we have, by showing the SOPs that we follow, and we have not had a problem explaining and allaying these fears of the owners. But still, if owners insist on changing the crew national, then the cost is on the owners, because in the SHIPMAN, the Annex B, where you mention the crew list, we as a policy also mentioned the crew nationality. And so the agreement is that this particular Annex C budget is for this amount or complement of Annex B crew from these countries. And if the owner then comes that I want to change this premise and change now some other nationality, then of course we help him, we educate it, allay those fears, and if he still insists, we would help him, and then the costs would be on him, and easily changing the costs of crew nowadays is anywhere between $2,500 to $3,000 per person. So easily changing 20 crew would, on his account, sending 20 crew and bringing 20 crew is 14 to $2,500 US. So that's a lot of money.
Right. Katherine, there's one for you from Mr. Prabhakar. It says, fines imposed on a ship due to negligence by ship staff. It's not a willful default. Can owners say that the ship manager has to pay this as the crew is employed by managers?
No. the basic principle is that managers are not liable to owners unless managers or their employees, agents or subcontractors are shown to have been negligent, grossly negligent, or willful or in willful default of performance of the management services. So my understanding on that basis is no.
Okay. Yeah, this is a bit of a dodgy one anyways. Yeah, Vikas, you're saying something?
Yes. So I don't think as well it should be an issue. So yeah, I would agree with Catherine.
Okay, I think we're coming up to, well, just past 6 o'clock mark, so I'll just take one more. It's for Martin. Can there be any obligation on managers for not maintaining transparency in expenses for maintenance of ship's operation?
I'm not quite sure I understand what he's asking. What is he? Is he asking that I should be obliged to be transparent in expenses? Of course I would. Why wouldn't I? Why wouldn't anyone? It would be crazy not to. Why would you want to hide something or hide a cost? You must be open and upfront from the start. Otherwise, you can expect some kind of problem from the other side.
Fair enough. I mean, transparency is the name of the game, right? So
yeah, of course.
Fair enough. All right. Yeah, that should pretty much cover it. I have to ask Jagmeet-san because he has something to add on BIMCO feedback. Jagmeet-san, if you want to step in now.
Yeah, thank you so much, Sharath. Let me try and get this thing on. Yeah, because the chat box doesn't get recorded, doesn't get saved. So we have a feedback from BIMCO, which is very, very positive feedback. And thanks to them. And thank you to all the panelists that for this feedback which BIMCO has given us. So let me read it out so that it becomes part of our recording. From BIMCO's perspective, SHIPMAN 2009 is a very successful and widely used standard agreement. However, it is now 11 years old, and we appreciate that users are increasingly adding rider clauses and making amendments to cover issues such as sanctions, anti-corruption, MLC, and cybersecurity. We have listened to feedback from the industry and have concluded that we should now update the SHIPMAN and also associated crew management agreements. So all the issues your panelists have raised today are really useful to hear for BIMCO. We hope to start working on an update at the end of this year. And we will consult with the industry so that they get a new SHIPMAN and address all the suggested improvements. Thank you. Thank you very much, Grant, Anna, and everyone at BIMCO. Thank you.
Okay, thank you, Jagmeet-san, for sharing this with us. We will take one more last question from Mr. Suresh Prabhakar. This question, and any of the panelists, please feel free to give your inputs. RightShip now rates companies DOC. Some large charterers will not accept a ship with a DOC rating below 3. When large ship managers provide services to multiple ship owners, if their DOC gets downgraded to a rating of 2 to a major incident on board an owner A's ship, but this results in owners B, C, and D unable to fix their ships to charterers requiring RightShip approval. How does SHIPMAN make the manager answerable to owners B, C, and D?
It does not. So thankfully, fleet management DOCs are all 5-star in terms of safety scores of 5, so have not faced these issues. But we see peers in certain markets whose DOC has gone to 2. They have worked with RightShip to get it to 3. So it's not an insurmountable task to get it up by talking to RightShip, getting the office audit done. But even so, I think it's good that owners think the way they do, and it has consequences. And so the obvious consequence or rider clause can be similar to what tanker owners usually do for oil major acceptances. So they usually, it's in the charter parties and they try to do it back to back in the ship management agreement, that should the vessel lose oil major approvals or the DOC manager lose oil major approvals, then owners have the right to terminate, and consequently you can negotiate what would be the consequence of that, because truly, in case it's not because of that ship of that owner, it is fair to him to expect some recourse. So that can be negotiated, and it should be the same for right ship.
Right.
The related issues, I mean, it will have to be separately agreed. There's nothing at present which allows them to do that. And Katherine can add more from her experience of this.
Katherine?
I agree with you, Vikas, that yeah, it's a complex one, but I agree it's something that's got to be discussed and negotiated separately. Yeah, I would agree with the points that Vikas has made on that issue, actually.
Right. So that's something which we do have to keep in mind, especially when we take on multiple owners under a single DOC in the ship manager's office. That is definitely one area which is of concern. Okay. Martin, any thoughts on that one before we close?
No, nothing on that, I'm afraid.
That's fine. That's all right. Okay, then in that case, we are now well within our time, and I would once again take this opportunity to thank all three of you. I appreciate the effort which goes into preparing for such webinars, and appreciate the effort which you've taken, the time which you've taken out. And also the 100+ participants which we had on the webinar today. It was great having them, and the interactive questions which we had. So on behalf of the Hong Kong, Singapore and Middle East branches of the ICS, I would once again like to thank all our supporting organizations and the media partners as well. And we're looking forward to the next ICS Hong Kong webinar, which is actually a joint webinar with Vista on the very contentious issue of charter party disputes. It's on 11th August, so we look forward to seeing you all then.